It's time for Elder Law Matters Radio. Elder law issues can be overwhelming and complicated for families to deal with. Elder Law Matters will demystify all areas of elder law and estate planning through conversation, interviews, and case studies. Each week, partner Melissa Negrin-Weiner will walk you through the twists and turns of planning for your future or caring for an aged loved one. If you want to protect yourself and your family and preserve your assets, or if you're a caregiver for an aged loved one, then Elder Law Matters Radio is for you. Now it's time for Elder Law Matters Radio with your host, Melissa Negrin-Weiner.
Hi, this is Melissa Negrin-Weiner from Genser Cona Elder Law, and you're listening to our podcast, Elder Law Matters. Thank you for joining us. Today's podcast, we're going to talk about protecting the family home. So many people who are interested in elder law and estate planning and asset protection, especially on Long Island, are very much focused on protecting their real estate because here, most of the time, that's the largest asset of the family. So we often talk about different ways of protecting the home when we're doing some asset protection planning, and there are a few ways to do it. The first thing I want to mention is for Medicaid purposes, we can transfer houses between spouses. So those transfers are exempt. So if we have a husband and wife living in the home and one of them needs to go to a nursing home, we can transfer the house to the other one, the well spouse, and we can qualify them immediately for care in a nursing home. Medicaid will not penalize you for transferring your home to your spouse. So that's kind of the easiest way to protect the home. That's kind of the quickest way to do it if there's a married couple. Now, when people come in for planning and they're not going into a nursing home tomorrow, it's a little bit of a different scenario. We want to pay attention to the fact that there is a 5-year look back for nursing home Medicaid. We want to get the house out of the couple's name, or if it's one person or if it's a married couple, we want to get the house out of their name, and we want to start that 5-year clock as soon as we possibly can. So people start doing this, maybe even around 55 would be terrific because that 5 years then will typically come and go without any question or any problem, hopefully. So how do we do it? Well, we can transfer the property to a child, all right, or to multiple children. Not something we typically recommend. And the reason for that is once you transfer anything to another person, that asset then belongs to that person as far as the rest of the world is concerned. Okay, so that means if there are creditor problems, if there is a lawsuit, if the person gets divorced or has kids in college on financial aid, whatever the situation may be, the property that you have transferred to that person is now going to be vulnerable to anything going on in that person's life, like the things that I mentioned. So it's really not the ideal way of transferring the property. What we typically will recommend is transfers to an irrevocable trust. Now, you may talk to people, I have clients that come in all the time and they'll say to me, well, my neighbor so-and-so, they transferred it to their son and everything was fine and it wasn't a problem. And that's fine. And, that's sometimes we have to do it, but it's not what we recommend. Back in prior to February 2006, when all the Medicaid laws changed, it was very common to transfer to children because there was a 3-year look back when you transferred to an individual and a 5-year look back when you transferred to an irrevocable trust. So typically the benefit would outweigh whatever the risk was, to transfer to the person versus waiting an extra 2 years. Now it's 5 years no matter who you transfer to. So now it's much safer and makes much more sense to transfer to the irrevocable trust. So basically, those are your 2 ways of getting the house out of somebody's name for Medicaid purposes, either transferring to another person or transferring to an irrevocable trust. Now, once the property's in the irrevocable trust, people are always concerned, well, what's going to happen to my tax exemptions? What if I, want to stay in my house and the people, the trustees, the people who are in charge of the trust, what if they want to sell it? How do I make sure that I'm protected? So there's a couple of things to kind of keep in mind. When we draft an irrevocable trust to preserve somebody's real property, we always put language in there that's the equivalent of what's called a life estate. So if you were transferring the property to, say, a child directly and not to a trust, we would build the life estate language right there into the deed. But in this case, we put the language in the trust. And that language basically says that the person who's transferring the property has the right to live in the property as long as they're alive. And also they keep their tax exemptions. So if they're getting STAR or Enhanced STAR or a Veterans exemption, they get to keep all those exemptions in place even if the house is held by the irrevocable trust. That's a huge benefit. Also, the house can't be sold out from under them, so that fear that somebody's going to kick them out of the house is alleviated with that language in there, that they have the right to use and possession for their lifetime. So that basically is the only thing that happens when you transfer the property to the trust. Other than that, you feel nothing other than the change on the deed. So it's really a no-brainer to transfer real property as soon as possible. There's no downside to it. If you decided you wanted to move, you could sell the property. The trust would be the seller as opposed to you as the individual. The trust would sell the property. The money from the sale would go into an account also in the name of the trust. And you could then use that money to purchase another piece of property. Say you're downsizing. The trust could then purchase a new piece of property. The good news is the 5-year clock that started running when you initially transferred your house to the irrevocable trust, that clock keeps on going. Okay, so it's an excellent way to preserve that asset, which again is typically the largest asset. A couple of other exemptions to keep in mind. I had mentioned right in the beginning of this podcast that if we transfer to a spouse, Medicaid doesn't penalize you. There's also another special exemption, and that's a transfer to a disabled child. Now, we don't do this very often, and the reason why is many times if somebody is a disabled child, they're also on government benefits. So we have to be very careful when we transfer assets to a disabled individual because we don't want to upset their own government benefits. So that's just something to keep in mind if you're in that situation where you have a child who's collecting disability, that they're potentially somebody you could transfer to, but that has to be looked at very carefully by the attorney who's handling the transfers. But the other transfer that we typically will utilize is something called the caretaker child exemption. The caretaker child exemption is if the child is living in the home for at least 2 years prior to the parent's need for a nursing home, Medicaid will allow the transfer to that child with absolutely no Medicaid penalty whatsoever. It's called a caretaker child exemption, and in order to prove that you are a caretaker child, we would need to give Medicaid a copy of your birth certificate proving that you are indeed a natural child, and also 2 years of your tax returns showing that that address is where you file your tax returns. That way we're showing that you are indeed a child. Of course, adopted is also allowed for this. What is not allowed is stepchildren, nieces, nephews, grandchildren. It truly is a caretaker child exemption. And the idea behind it is that this child being in the home for 2 years has allowed the parent to stay out of a nursing home. So the caretaker child exemption is a great exemption to utilize. People sometimes are concerned if they have multiple children, they ultimately want to leave the home too, but they're transferring it to just this one child to take advantage of the exemption. And that's something for the children to deal with later on. But, it's really worth it to protect the house, the entire house. It's a great exemption, especially if we're in a crisis situation where planning hasn't been done. It's a good exemption to take advantage of. So that's also something to to keep in mind as a possibility of protecting the family home. So we have a really interesting story of a client who had gone to an attorney who was familiar with the caretaker child exemption, but not necessarily an attorney that practiced in the elder law, world on a regular basis. And what happened is this client came to us because his mom had been on Medicaid, and when she passed away, he got a collection letter from Medicaid for the house that they wanted to collect what they had expended on his mother's care from the sale of the property from her estate. And my first question when he came to me was, well, why does she have an estate? Why is the house still in her name? And he said, well, he knew that I was a caretaker child, but he said that was enough. The fact that I was a caretaker child, the house didn't physically have to be transferred to me by deed, which is absolutely incorrect. So, we run into these things all the time where, things are kind of done halfway because maybe a person doesn't, practice this area all the time. And that's, that is what it is. I couldn't handle a matrimonial proceeding because I don't handle matrimonial proceedings. But unfortunately, people try to, dabble and do things here and there, and they really end up hurting the family. So in this particular case, we had to file for a fair hearing with the Department of Social Services and explain that this person was the caretaker child. The transfer would have been exempt had it been made when it was supposed to be made. And we had to argue based on that fact that they shouldn't be able to collect against the property. Also, it was the son's primary residence, so if they had to collect against the property, he would have had to sell the house that he was living in. So after the hearing, we were able to turn it around, and we were able to avoid the Medicaid attaching the house and trying to collect from it because of the argument that he was a caretaker child, and had the property been transferred at that time, it would have been exempt anyway. But it was a difficult burden to prove. It took a lot of time. Unfortunately, it cost him some legal fees, and it really shouldn't have had to. So just the importance of these little nuances that I've gone over in today's podcast of making sure that you're working with an attorney who really, specializes in this area, or who really deals mostly with elder law and knows all the ins and outs. And and we can help you. We can help you protect the real property. So thank you again for joining us. We're going to go to Jen now for her quick update, and we will talk to you again soon.
How do you feel about telehealth? That's where you can have a healthcare visit, a doctor appointment, or even get a physical exam over the computer or smartphone. Most major health systems now offer telehealth services, but studies show that people age 50 to 80 are not buying in. Some concerns include that the quality of care will not be as good, that a physical exam would be impossible, that people will feel disconnected from their health care provider, and many people had privacy concerns. In reality, more than 50% of those surveyed did not even know if their doctors offered telehealth visits. So what about you? Would you be comfortable with a telehealth checkup? How about for emergency care, like if you had strep throat or the flu? Imagine not having to go out to the doctor on a snowy, icy day if your doctor could see you over the computer and call in a prescription. I'd love to know how our listeners feel about it, thumbs up or thumbs down. Email me at elder@genserlaw.com and let me know what you think. But here's something else to consider. This is a generational issue that is wrought with trouble if families don't keep the lines of communication open. Let me explain. I may be perfectly comfortable with a telehealth visit. I'm a busy professional. I do most things via webcam, whether it's work meetings or talking to my kids. It's routine, efficient, and a more than adequate way for me to get things done. However, Mom does not have the same frame of reference. As Mom's caregiver, if I insist that Mom have a telehealth visit instead of taking her to the doctor, Mom may feel that I don't have time for her, that work is more important than taking her to the doctor, that I'm not taking her health concerns seriously, that I'm not a good caregiver, that she's a burden, and a whole host of other unintended things. So instead, I need to talk to Mom. I need to ask if she's okay with a telehealth visit. I have to share with her how it works for me and see if she's willing to try it. We simply need to communicate about it openly and honestly so we each know where the other person is coming from so there are no misunderstandings. And of course, I need to respect Mom's decision. If you need help with family communications, our Elder Law Mediation Department can help. You can also find our communication tips on our website, genserlaw.com. That's GENSERLAW.com. You can go to the Resources tab and look for our free compassion tips to help with communication.
Thank you again for joining us on this episode of Elder Law Matters. And please remember to check out our website at genserlaw.com and check us out on social media. We have a great social media page, Facebook page that is chock full of information. Also, if you have any questions you want to ask me directly, you can email me at melissa@genserlaw.com. Look forward to speaking with you all again soon.
Thank you for listening to Elder Law Matters, the only show that talks about elder law and estate planning. For more information, check us out at genserlaw.com.